didn't pursue these three allegations relating to the rights to property, rights to freedom, and right to work. Therefore, the court will not examine these allegations in the present judgment. I'm now coming to the respondent's submission on the merits. For its parts, in its response of 26 February 2014, the respondent contests the allegations made by the applicants. During the public hearing of 21st May 2015, the respondent restated its position and refuted the allegations by stating that the applicants, I quote, upon receiving leave to file for prerogative orders, proceeded to do so and filed miscellaneous cases, case 16/2006 at the High Court of Tanzania at Moshi on 19 June 2006. This was an application for orders of certiorari and prohibition in the matter of forceful kidnapping and abduction of the applicants from the Republic of Mozambique by the Tanzanian police in collusion with Kenyan and Mozambique police. End of quote. According to the respondent, I quote again, it was not an application for fair trial, but rather it was seeking to be released so that the cases or charges against them would not proceed within the local jurisdiction. There were no human rights issues raised in this application. End of quote. I'm coming now to the court's findings on the merits of the application. The court takes cognizance of the fact that in the application, the applicants alleged that the Tanzanian police, I quote, forcefully kidnapped and abducted them in collusion with Mozambican and Kenyan police officers, end of quote, and illegally handed them over to Tanzanian authorities, and that they have challenged their alleged forceful kidnap and abduction in the High Court of Tanzania at Moshi, and this case, I quote again, has been delayed since January 2006, end of quote. However, it is the court's understanding that what the applicants have actually brought before this court is the alleged prolonged and undue delay in finalizing this case of alleged forcefully kidnapped and abduction, which is criminal application 16 of 2006, which is still pending before the High Court of Tanzania at Moshi, together with criminal case number 2 of 2006 and criminal case number 10 of 2006. The court is therefore not called upon to investigate the circumstances under which the applicants were brought into Tanzania, a matter that was raised only before the domestic courts and not before this court. Although not mentioned in the application or in their reply, at the public hearing, the applicants also state that they were not provided with legal aid. It is now to these two allegations that the court will turn. These two allegations fall within the scope of the rights guaranteed under Article 7 of the African Charter, which provides inter alia that, I quote, every individual shall have the right to have his cause heard. This comprises the right to defense, including the right to be defended by counsel of his choice, and the right to be tried within a reasonable time by an impartial court or tribunal. End of quote. I will start with the alleged violation of Article 7 of the African Charter on account of alleged prolonged and undue delay in finalizing cases at the national courts of Tanzania. Concerning the alleged violations of Article 7, the court would like to emphasize the importance of a speedy judicial process, especially in criminal matters. Justice delayed is justice denied is a maxim that is often used in this regard. If society sees that judicial settlement of disputes is too slow, it may lose confidence in the judicial institutions and in the peaceful settlement of disputes. In criminal matters, the deterrence of criminal law will only be effective if society sees that perpetrators are tried and, if found guilty, sentenced within a reasonable time, while innocent suspects undeniably have a huge interest in a speedy determination of their innocence. In the instant case, the applicants submit that they filed the case in the High Court of Tanzania on 19 June 2006. And as the time they filed the application before this court, that is 23rd July 2013, the matter was still pending before the domestic courts of the respondent. Whatever time computation the court adopts, it is clear that the matter brought before this court has been pending in the courts of the respondent for at least 6 years. Having determined that the length of time the matter has been pending at domestic level, the court will now proceed to determine whether this time is reasonable or not, within the meaning of Article 7, paragraph 1 of the Charter. The court notes from the onset that there is no standard period that is considered as reasonable for a court to dispose of a matter. In determining whether time is reasonable or not, each case must be treated on its own merits. As the jurisprudence of the European Court of Human Rights reveals, several criteria may be used to determine whether time is reasonable or not, including, inter alia, first, the complexity of the case, second, the behavior of the applicant, and third, the behavior of the national judicial authorities. The court will therefore use these three criteria for its assessment of whether or not the duration of the proceedings before national courts of Tanzania was reasonable. The first criteria, complexity of the case. To determine the complexity of a case, all aspects of the case must be considered, as the complexity may concern questions of fact as well as of law. First, this court does not believe that simply because the accused persons are many, a matter before a court is automatically complex. Besides, by linking the prosecutions of the applicants to other cases pending before another court whose proceedings were outside the control of the respondent means putting the rights and personal liberty of the applicants at the mercy of a foreign jurisdiction. This was a gamble, and one which ended up badly, because in the end, the so-called other suspects facing extradition from Kenya never appeared. The fact that the respondent finally decided to proceed with the trial of the applicants after failing to secure the extradition of the other suspects from Kenya demonstrates that it was possible to separate the cases and prosecute them ab initio. The delay has therefore nothing to do with the complexity of the case and was as such unjustified. I'm coming now to the second criteria, which is conduct of the applicants. Thank you. During the public hearing, respondent claimed that, I quote, delays in the cases were not strictly by prosecution. There were instances when the defense counsel did not make appearance. There were instances where defense counsel was sick. There were instances when defense counsel was appearing before the Court of Appeal, superior courts, and what happens when you attend the superior court? Naturally, you don't attend the lower court. So these allegations of delay were not by the respondent. End of quote. The court take notes of the respondent's arguments that defense counsel may have played a part in the delays, in that they were sick, did not appear, or preferred to appear before superior courts in other cases. But it does not demonstrate the extent to which this action of defense counsel delayed the proceedings, or whether they deliberately wanted to delay proceedings. There is no evidence before this court to indicate that any of the action of the defense, as narrated by the respondent, was aimed at stalling the process. The court therefore dismisses respondent's argument according to which the applicants were partly responsible of the delay. I'm coming now to the third and last criteria, namely the conduct of the domestic judicial authorities. Throughout the cases, the applicants constantly questioned the very length of the trials, up to a year after they had been charged. The most frequent reasons for seeking adjournments was that they were still constituting the police file, that investigations were still ongoing. End of quote. The respondent did not challenge this assertion by the applicants. Even assuming that the defense counsel were trying to delay the process, there rests a special duty upon the authorities of domestic courts to ensure that all those who play a role in the proceedings do their utmost to avoid any unnecessary delay. Judges also have the right, as well as the duty, to actively monitor and ensure that judicial proceedings before them comply with the reasonable time requirement. On the basis of the above, this court concludes that the time was unreasonable, not because of the complexity of the case, nor the action of the applicants, but more so because of the lack of due diligence on the part of the national judicial authorities. The court cannot condone the respondent's action of putting the case on ice for a period of almost 2 years on the ground that the authorities were still investigating the matter, or because they were waiting for the extradition of co-accused from another foreign jurisdiction. The court thus finds the respondent in breach of Article 7, paragraph 1, subparagraph D of the African Charter, which guarantees the right to be tried within a reasonable time. I will now turn to the second allegation made by the applicants, namely alleged violation of Article 7 of the African Charter on account of alleged failure to provide applicants with legal aid. In the application of 23rd July 2013 and their reply of 31st March 2014, the applicants were silent on the question of legal aid. However, during the public hearings, they raised the issue and stated that they need not have applied for legal aid for it to be granted, but rather that the trial magistrate and appellate judges had an obligation to inquire into whether or not they qualified for legal aid according to the criteria set out in Section 3 of the Legal Aid Act of the United Republic of Tanzania. During the public hearing, the respondent refuted the applicant's allegations and argued that, I quote, "Throughout the trials, the applicants had defense counsel. They were able to afford defense counsel. This is documented in the proceedings. There was Mr. Ojari and Mr. Mwale, and judgments that we have produced will also show that they were suitably and adequately represented by seasoned defense counsel." End of quote. The respondent further avers that, I quote again, "The applicants have always had legal representation. They have never requested for legal aid via the Legal Aid Criminal Proceedings Act of Tanzania, and are yet to request and apply for legal aid via the provisions of Chapter 21. Therefore, it will be unfair for the court to issue such a declaration, as the applicants have not even made it known to the respondent that they require legal aid and legal representation." End of quote. It will appear from the facts before this court that applicants have been represented all along by counsel, which they or their relatives engaged. It is not clear whether, if they had not engaged counsel, the respondent would have provided them with counsel. What is important, however, is that they had counsel, at least up to when their counsel deserted them. It is also clear from the pleadings that the applicants are not claiming that the respondent should have provided them with counsel throughout the trial, and it is not correct to expect the respondent to provide legal aid to the applicants who already had counsel of their choice. It should, however, be noted that when applicants filed this application before this court, they had been deserted by their counsel and still had cases pending against them in the respondent's courts. And the respondent was aware of the situation. Given the serious nature of the offense that the applicants had been charged with, the court is of the view that all necessary measures should have been taken by the respondent in the interest of justice to ensure that the applicants were afforded legal assistance. While a state cannot be held responsible for every shortcoming on the part of a lawyer appointed for legal aid purposes, it is for the competent authorities to take steps to ensure that the applicant effectively enjoys the right in any particular circumstance. This court also notes that legal aid is specifically guaranteed in the legal system of the respondent state, including the Constitution and other legislation, and that various judgments of the High Court and Court of Appeal of the Republic of Tanzania have emphasized the need for legal aid. Given the serious nature of the charges against the applicants, this court is of the opinion that the respondent was under an obligation to provide them with legal aid, or at least inform them of their right to legal aid when it became clear that they were no longer represented. It does not matter whether the case is at pre-trial, trial, or appeal stage. The applicants are entitled to legal aid at all stages of the proceedings. The court does not accept respondents' argument that the applicants did not complain that they were aggrieved by the advocate's departure and required legal assistance. Legal aid is a right and must be enjoyed whether requested by the accused or not. The essence of providing legal aid is to ensure a fair trial process and avoid the possibility of miscarriage of justice. Where the applicant is not informed of this right or does not invoke this right, the onus is on the judicial authorities to activate